We're very fortunate to have Andrew Mueller with us today from Legal Action of Wisconsin. Andrew, I'm going to let you take it over here and tell us a little bit about yourself, how you got into this important field of legal practice, and then take off with your presentation. All righty?
Yeah, absolutely. And I'm glad to be here today. So like you said, my name is Andrew Miller. I've been calling me Andy, Attorney Miller, whatever feels most comfortable for you. So I just hit my 5-year mark for an anniversary at my firm as an attorney. And before that, I'm a double badger. So I graduated both from UW with majors in political science and philosophy and a minor in environmental studies. And then took a couple years off. Then I went to law school where again, at UW where I interned with the Consumer Law Clinic and then also interned at the exact position that I'm in at the Elder Rights Project at Legal Action of Wisconsin. So I will go ahead and share my PowerPoint. And while I'm doing that, I guess I'll just let y'all know something that I let Mike know as well. So I'm currently getting over being sick for about 2 weeks, and simultaneously, my 4 month is also dealing with sleep regression. So apologize for not at the top of my game, but I'm here, you're here, and I'm confident that we'll all at least, maybe, if not have a good time, we'll at least learn something. So all right, so can you see just my presentation mode right now?
Yes. I see that there's one slide on the side here. The next slide is also visible.
Okay, bear with me then as I try to figure this out. Content only. Okay, is it still showing where let me
It's not showing your screen. There we go, but I still see this next slide.
still see the next slide. All right. I swear to God, I've done this properly in the past. Okay. Okay, maybe.
There we go.
Okay, is it just the one slide?
Yes. Yeah.
Okay, sounds good. All right, so let's move through this. So that's my information. As I said, I'm an attorney with Legal Action of Wisconsin. So we're a law firm here in Wisconsin, the biggest nonprofit law firm in the state. And this presentation will be talking about my firm as a whole, and then also just my specific project, which is the Elder Rights Project. And then after that, I'll be talking about financial exploitation, and specifically today, I'll be talking about financial exploitation by a known individual, so typically a fiduciary, guardian, power of attorney, that kind of thing. But I also do a lot of work in other areas of financial exploitation, scams, that kind of stuff. So if there's anything else any other questions you have for stuff that's not in the slides, like I said, feel free to interject and I'll kind of talk about that. So that is my personal contact information right there, my direct line and my email. I will note that it's also on the last slide. So if you're not writing stuff down yet, but you want to in the future, you'll have another opportunity at the end. All right, so here's Legal Action of Wisconsin. At the top there is our intake number. So that's a toll-free number that we give out for any new callers that come to us. So we're a nonprofit law firm that was established in 1968. And our mission is to provide free civil legal services to low-income people who would be denied justice without our help. We'll get into this in a little bit more, but here at the Elder Rights Project, we actually don't have any income and asset restrictions. But as a whole, for most of our projects, we strive to serve low-income individuals. And something that's fairly new and fairly exciting is we now serve clients statewide. So until the beginning of this year, before the beginning of this year, we used to only serve the bottom half of the state, so the 39 southern counties, and now we merged with a firm called Judicare, and now we are statewide. And then at the bottom there is our website. All right, so this is for legal action as a whole again. So these are kind of areas of practice, our common areas of practice. So we do housing work, so that is a lot of eviction defense. We do some foreclosure work, that kind of stuff. We also do consumer matters, which can include, debt collection and garnishment. We do some family, so that's both restraining orders and also divorces, child custody cases, that kind of thing. And we do public benefits, so helping people sometimes, I believe, depending, I think that's more in the Milwaukee area, but we can help people apply for public benefits. But also if people are denied public benefits, so unemployment insurance or like disability, that kind of thing, we can potentially help with more of the later stages of the appeals in front of administrative law judges, that kind of stuff. And we also do a lot of barriers to employment work. So that includes expungement of criminal records that shouldn't be on there anymore because they were the result of, someone was arrested, but no charges were filed, getting that kind of stuff off their record. And we also do try to get pardons from the governor. So these are services that we do not offer for one reason or another. So we do not do any criminal representation, whether prosecuting crimes or criminal defense work. We don't do any workers' compensation. We don't do any employment discrimination. And then there's certain stuff that we are kind of barred by Congress because we get a lot of our money through something called the Legal Services Corporation, which is through Congress. And the laws of the United States say that people that get that money aren't allowed to take certain types of cases. So that includes immigration cases, school desegregation, and abortion-related issues. And then we're also not allowed to take cases where there's a number of private attorneys that will take the case on what's called contingency, which is essentially you only pay for attorney's fees if the attorney wins or if you win your case. And so those are most commonly personal injury cases. So here's a little bit of information about my specific project. So as I said before, I work under the Elder Rights Project. So we are funded through something called the Victim of Crime Act, which was an act that passed Congress back in 1984. The kind of cool thing about VOCA funding versus other types of funding, such as the Legal Services Corporation, that funding I mentioned earlier, is that VOCA is provides grants that are funded by fines and penalties of federal criminal cases, not general tax revenue. So my salary isn't paid by general tax revenue; it's paid by going after criminals. One thing I will say that a lot of the people on this call are probably fairly familiar with is that about a year and a half ago now, we kind of nationwide, we experienced severe budget cuts um, for VOCA funded projects or programs. So for a little bit of, I guess, sort of clarity or to kind of provide an example. So this time, I'd say 2 years ago, I think we had 7 or 8 full-time attorneys covering what as I previously said, was previously the bottom half of the state. Now I'm the only full-time attorney, and now we cover the entire state. So unfortunately, we're of course a little bit stretched thin compared to where we used to be. That means that we are doing more like, brief services or advice cases than we are doing extended representation, but we are still taking extended representation cases and, I'm here, we're talking, so we're still open. So back in 2016, Legal Action of Wisconsin partnered with Judicare. That's that firm that I mentioned previously covered the top half of the state. And we sort of had sister programs. So ERP in and of itself has always been statewide, or at least since 2016. And what we do is we provide free civil legal aid to victims of elder abuse. So here's kind of the map. Again, this doesn't matter as much anymore, but just to kind of explain the evolution of our program. So on the left, that's what formerly was just the legal action service area, and on the right was formerly the Judicare service area. But now all of those counties are covered by legal action. Give me just a second while I cough. All right, so this is our mission statement at the Elder Rights Project. We aim to assist in securing safety, stability, and independence for victims of elder abuse. All right, so you may be thinking, what exactly is elder abuse? So, elder abuse is actually defined in Wisconsin statutes, Wisconsin Statute 46.90, and that is physical abuse, emotional abuse, sexual abuse, treatment without consent, which can include under-medicating and over-medicating, unreasonable confinement or restraint, financial exploitation, which we will talk about today, and also neglect. All right, so this is a little bit on the eligibility specifically for Elder Rights Project clients. So you just have to be a Wisconsin resident. Although I will say on that note, actually, I have had a fair amount of clients that aren't Wisconsin residents anymore, but they were when the victimization took place. So let's say, for example, like this is a case I had recently. Someone, their daughter convinced them to buy a house with them, and then they subsequently essentially kicked their parent out. The abuser did. The abuser had to flee back to the East Coast where the rest of their friends and family were. So then we represented in that dispute with the daughter because the house and the actual dispute was based in Wisconsin. So you need to be 60 and older. I believe that's defined by federal law. I believe the Older Americans Act defines older Americans as 60 and older, so we have to go by that. You have to be the victim of elder abuse, so our very technical term for it is there has to be some sort of crimey element to your case. As I previously mentioned, we actually don't have any income or asset limitations at the Elder Rights Project. That's really nice because, that means we can prioritize kind of safety issues. Let's say someone needs a restraining order. They come to us. It's a dire situation where the person's safety is really is seriously at risk. Let's say they have a bunch of money in the bank, but they might not be able to find another attorney in short order. We can step in, even though they might be able to afford to pay an attorney. We can step in and take the actions necessary, like getting a restraining order or something like that, to try to keep them safe. That being said, if it's less of an emergency situation and the person has $1 million in a bank account, we might still tell them, hey, you should probably just go find a private attorney. And then lastly, the person just needs to have some sort of civil legal need due to the elder abuse that they're suffering from. Right. Bear with me just a second here. Okay. So these are some of the services that we are commonly able to provide. As I said, the amount of capacity we have for different issues is not nearly as much as it used to be. And so it really kind of depends on what I have on my plate, what my program director has on her plate, that kind of stuff. But these are kind of just some of the common services. So first, we can provide advice on consumer matters. So that might include stuff like bankruptcy, or FDCPA, so the Federal Debt Collection and Practices Act. So we can provide guidance on like debt collection if it's related to the abuse. And then we can also provide advice on like someone being collection proof or judgment proof, which is, yeah, maybe let's say someone took out a debt in their name, they're a victim of identity theft. But when push comes to shove, they don't have any assets or income that can be garnished or taken if they were to be sued. We can provide them that sort of guidance. So we can help get restraining orders. So that's domestic abuse injunctions. The type of restraining order that I typically like to file is actually called an individual at risk injunction, which is specifically for people that are 6 year older or otherwise a vulnerable adult, and they're suffering some sort of abuse. And then there's other type of protection orders that, at least in theory, we can get. Although I will say those are typically the two that we tend to stick to. So revoking powers of attorney. So we can also kind of request to seek review of an abuser's conduct either through the court or sending a demand letter to the power of attorney, and then revoke that power of attorney if needed. So we can recover stolen money and sometimes property. Although I will say as we are dealing with less staff, we kind of had to make some hard decisions on what sort of cases we do and do not have resources for. So, for example, we right now aren't taking any divorce cases because those just tend to be very resource intensive. So, if we were taking divorce cases, 4 or 5 divorces could take up pretty much all my time, and then we wouldn't have time for anything else. So one of the things that we decided we don't really have the resources for is helping people recover property, like personal property. Although I will say, even those cases, a lot of the times we can at least provide advice, and sometimes we will still recover property if it is related to stolen money. Like, it's kind of they stole $30,000 from me, oh, and they also stole this property. And if we're going to be filing a case anyway, then we can rope that property in. So we do also do land fraud, such as a filing of a fraudulent deed, like that someone forged, or like if someone signed a deed through undue influence or fraud, that kind of thing. We help just stop abuse in general, or stop the bleeding, as we sometimes say. So that's like stopping financial abuse and providing advice on safety planning, how to, what to do if it were to happen again. We can evict the abuser. So we can essentially launch eviction proceedings to remove the abuser from their home. This puts us, I don't want to say at odds, but it's different than a lot of what we do as a firm. We're kind of known a lot for our eviction defense work, but we, at least specifically in our project, do also evict abusers from homes sometimes. Although I will say our standard operating procedure is that we typically won't take that step, like getting an abuser out of the home, unless we believe that it qualifies for a restraining order. But for one reason or another, maybe, we're in a county where the judges aren't as don't construe restraining orders in the way that they think, or, the person just doesn't want to get a restraining order. Let's say it's against their kid and they want to maintain contact afterwards. But whatever it is, in order for us to be willing to file an eviction, the abuse has to be to the level that we believe. Otherwise, a restraining order would be appropriate. So we also defend against evictions or foreclosure proceedings if the eviction or foreclosure is related to the abuse or neglect. And then we handle other civil legal problems. So we provide identity theft advice. We advise on benefits terminations that may happen due to abuse. We do some scam work. I know that's something that's really in a lot of need right now. Like scams are really on the rise. I will say from a legal perspective, in terms of like trying to recoup money, there's not a whole lot we can do in terms of, trying to get money back from an unknown individual. So let's say an overseas scammer. So I believe right now, actually, our intake line is closed if someone were to call with that issue. I think they might, I'm not sure. I don't work in our intake unit. They might receive like some sort of kind of brief advice or guidance. But I will say, a little bit reluctant to say that's on this call, but I will say if you reach out directly to me or we do like kind of a warm handoff or a warm referral, it may be more likely that the person can at least provide some or get some brief advice from our program. So today I'm going to focus on financial exploitation by known individuals. All right. So what is financial exploitation? So financial exploitation is taking a person's money or property or belongings either through deception, coercion, or force by abusing the financial authority that abuser has. So like we had kind of mentioned, a power of attorney or a guardian, stealing personal information, so identity theft, or forging signatures or documents. All right, so these are different types of financial exploitation. So manufacturing consent. So I guess I want to say, so for manufacturing consent, it's less of a cause of action, so like a reason to sue somebody, and more of a theory of a case. So how we might kind of like describe the financial exploitation. So it involves kind of like deceiving or enticing or coercing or compelling or forcing a person to give away or sell for less than fair market value their money or property. So, for example, a power of attorney might convince a principal, so the person who has the power of attorney, the power of attorney might convince the principal to sign a deed for their home over to them. There's a question of, was this transaction done knowingly or voluntarily? Was there like a meeting of the minds? So again, for example, let's say a daughter convinces a mom to sign over the deed, and she'll say, "Oh, I'll give you caregiving for the rest of your life if you sign over this deed to me." But then they kick the mom out of the home. We would say that they manufactured consent there. So yeah, maybe she did sign the documents, but it was kind of under false pretenses. So again, we help with or one type of financial exploitation is identity theft, or theft in general. Another one is forgery, which is falsely making or altering any writing with the intent to defraud. So, for example, signing an elder's name on checks or abusing financial authority by a trusted person. And that's what we're going to talk about today, abusing financial authority. There's multiple different types of fiscal agents. So there's a power of attorney for finances, There's a representative payee who assists only in kind of controlling someone's Social Security benefits. There's conservators of the estate and there's guardians of the estate. But power of attorney is by far the most common fiscal agent and the one that we're going to focus on today. All right. So, again, the abuse of a fiscal agent is defined by Wisconsin statutes. That's Wisconsin Statute 46.90, sub ED, sub 3, which is substantial failure or neglect by a fiscal agent to fulfill his or her responsibilities. So, I'm going to give an example of fiscal abuse. So, take client John. John was married almost 60 years, and his wife always took care of the family finances. So, he doesn't have much experience taking care of finances. His wife, Nancy, who did take care of the finances, she passes away. And less than 2 weeks after she passed away, John was approached by his neighbor, Tom, who offered to help him get his finances in order. Tom was a preacher and had always been very nice to him. So John agreed to sign a financial power of attorney, or a POAF, we sometimes call it. So this gave Tom immediate and durable authority over John's property. Tom began receiving John's Social Security and pension checks and putting them into a new bank account. Tom got a debit card for that bank account and used it to purchase things for himself. Tom also used the power of attorney for finances to retitle John's house and his car into Tom's own name. So even though Tom had control of all of John's income, he wasn't keeping up with John's bills. Eventually, John's phone, cable, and power were all shut off. All right, so we're going to talk a little bit about.
Andrew, can I jump in just a minute? What's that mean,
Yeah,
durable? You use that word durable. What is
yeah.
that?
So we are going to get into that in a little bit. That's on a
Okay.
future slide. Yeah, because so people commonly confuse that with springing, another term that's known in powers of attorney. But yeah, like I said, we'll get into it in just a little bit. So before that, I want to talk a little bit about abuse by the numbers. So these numbers are from the Wisconsin Department of Health Services from 2023, which is the most recent numbers that we have. So other than self-neglect, numbers that were reported to Adult Protective Services, financial exploitation is the most commonly reported type of case. So in 2023, there were over 3,000 cases reported. Oh, and I should say this is from Wisconsin's annual elder abuse and neglect report. So yeah, so of the abusers that were reported, almost a quarter of the total abusers were the children of the elders. But there's also 32% unknown, so it's likely higher than that. I should say actually this 24.7 and that 28.8 on the slide, these are from all cases reported. Unfortunately, they don't break these numbers down into, just financial exploitation, just self-neglect. So these are all the numbers. But then also 28.8% of the elders who have been abused have legal or substitute decision makers. And again, 22.8% are unknown, so it's likely actually higher. As we probably all know, many cases go unreported, so these numbers are likely low. So cases can go unreported for many different reasons. Either embarrassment, the person is just really embarrassed that they fell victim to this. They might think they're alone, or it's not as common as they think it is, or as it actually is. They may be dependent on the abuser. You see here, a lot of the abusers are children. They might be worried that if they report it, that these children are then no longer going to provide whatever care they are for them. They might be undiscovered crimes. The elder might not have capacity, and they might not actually even know things are going on, or they just trust them and aren't reviewing their statements regularly. Or they might want to be protecting the abuser. So as we said, a lot of them are children. They might not want to see their kid go to jail or to get a mark on their record that could affect their work. All right, so let's talk a little bit about what we said was the most common type of financial substitute decision makers, powers of attorney. So these are the powers of attorney. So a power of attorney is a legal document that grants somebody else authority to do or to not do certain things. So a power of attorney for finances can make decisions or take actions on your behalf. But you do still also have authority to sign documents on your own if you have a power of attorney. So it creates a fiduciary duty to act in your best interest. So they're not allowed to use that money for their own benefit or for their own interest. They have to use that money for your interest. As we said, it gives them the authority to sign documents, but it does not give them authority. A power of attorney doesn't give the agent authority to change wills. And we'll get into this in a little bit or a little bit further in a little bit, but you should always choose someone you trust. So choose someone without money issues, health issues, or mental health issues. And as you asked, Mike, so durable is the most common type of power of attorney. So a durable power of attorney is where it both becomes effective immediately, but the durable part of it is that it continues after you're incapacitated. So I think this is kind of like from the olden days, powers of attorney or these types of documents. They would remain in effect while the person could make their own decisions, but then when they would become incapacitated, it would no longer have effect. That's the durable part of it. It can survive the person becoming incapacitated, but not after death, I should note in there. So all powers of attorney, once the principal dies, they cease to exist. As I mentioned earlier, one thing people kind of confuse durable with is springing. And springing is basically means that it doesn't take effect immediately. It takes effect upon some future event. So, for example, healthcare powers of attorney, and people tend to conflate the two of them. There's two main types of powers of attorney, healthcare, financial. Obviously, today we're talking about financial. Healthcare powers of attorney don't take place immediately. They have a springing clause, and that spring comes in when two doctors or medical professionals deem the person incapacitated or unable to make decisions about their own health care. Um, so yeah, so that's springing. And so I will say financial power of attorney, they can be springing. So you can have a power of attorney that does not take effect immediately. That's not typical. And I know like the standard state court form, it takes effect immediately. And honestly, like I don't usually recommend that my clients do a springing power of attorney because, the main reason that people say, oh, I don't want them to be able to make decisions now because I can make decisions now and I don't want them to be making decisions. And my question is, if you don't trust them to make decisions now, why would you trust them to make decisions after you become incapacitated and you can't do anything about it?
That's a really good question.
I was wondering about that too, Andrew. If you may be judged to be incapacitated, but that doesn't mean the other guy is going to continue acting honestly. How would you, how would one get rid of a person who's abusing an incapacitated person? I mean, he's kind of like in charge after that, it seems.
Yeah, yeah, and so it does definitely put people in a tough spot because if you don't have the capacity to sign a new power of attorney or like appoint somebody else, I think there's a good argument that you don't really have capacity to revoke a power of attorney either. And so that's at that point, the person, especially if they're being abused by their power of attorney, really should just be put under guardianship. And if a guardianship is put into place, it essentially revokes the power of attorney automatically. And a lot of the times, a former power of attorney will be appointed as the guardian, but not necessarily. So yeah, and other than that, and we get into it in a little bit as well, but the one of the benefits of a guardianship is that there requires a yearly accounting in through the court system. So I mean, I will say there's arguments, especially county to county, as to how effective the court actually is in overseeing guardians' activities, but at least there's some sort of mechanism there. But you can also petition the court to review a power of attorney's actions as power of attorney. So that mechanism does exist, so somebody could do that. But of course, if the person's incapacitated, they're not going to be able to do it on their own. All right. So why have a power of attorney? So as we talked about, it allows someone that you trust to make decisions for you when you're eventually unable to do so. As we had talked about, like I said, honesty is number one. You have to make sure that you can trust the person, that they're honest, they're responsible. Again, they don't have any money management issues of their own, no addictions or bad habits. But I think, yeah, doing it early enough and especially if you feel like you need some help managing your accounts, that kind of thing, doing it while you can still kind of keep an eye on them and see how they do and see how they probably will continue to act after you're incapacitated, I think is usually a good idea. Another benefit of the power of attorney is you keep, unlike a guardianship, you keep the power to manage your own money as well. So you can still make decisions, and then as long as you have capacity, like we talked about, you can revoke the power of attorney at any time. People also use it for convenience. So, like we said, you can if you want, but otherwise, if you trust your power of attorney and they do a good job, then you don't have to be the one that stresses about paying the bills and taxes and stuff like that. And then it also can help prevent guardianship. So guardianships can be costly and consuming and time consuming to initiate or remove the person if they're a bad guardian. I guess, for example, on a personal level, so my brother is disabled and he no longer has legal capacity. I'm his power of attorney. And we set all that up while he still did have capacity. And he, no doubt about it, if we hadn't done that, he would need to be under a guardianship right now. But as it is, he doesn't really need to be because we're able to get everything that needs to be done with the financial and the healthcare power of attorney that are in place. And then importantly here, and honestly, potentially if you take one thing away from this presentation, is it can prevent the need for joint accounts, which are very susceptible to abuse. So joint bank account statements essentially give joint ownership to both parties. So that basically what it means is that, someone might add, again, for example, for again, a son or a daughter onto a joint account, thinking, oh, this is an account of convenience that can help me pay my bills. But what it actually does is it gives more or less, there's what we call a presumption of donative intent. So it essentially gives the person the presumption that that money also belongs to them. And so then they can just withdraw all of it. We hear stories from a lot of estate planning attorneys that, they created this carefully crafted estate plan for their clients. The clients, without thinking about it or really realizing the consequences, added one of their kids on the joint account to help them pay bills, but that's where most of the money was sitting. And then all of a sudden that kid drains the money and then, their whole estate plan is up in smoke essentially. So that's all to say. Don't have your clients or don't have you add someone as a joint account. There's almost always a better mechanism to do what you want to do. If the main thing is, let's say you want the money that's in the account to go to a kid once you die, because that's what joint accounts do as well. They're joint accounts typically with like what we call rights of survivorship. What you can do instead is you can do a payable on death. So basically, their name's not on your account now, but once you pass away, they can get access to that money with just a death certificate instead of having to go through probate. And then otherwise, if you don't want to do like a global power of attorney, so power of attorney to manage all of your financial stuff, first of all, as an aside, you can, in the power of attorney document, limit what their ability is if you don't want them to have a global power of attorney. But otherwise, if you don't want to make your own power of attorney document, most banks have their own proprietary form where they can add it as a POA just on your bank account. All right, so here's a little bit on the rights of the principal. So again, the principal is the one who's executing the document and appointing a power of attorney as their agent. So they have a right to choose their agent. So that you can pick someone you trust. It's not picked for you, which it often is in guardianship cases. You have a right to constant communication. So you have a right to get a response in a timely manner from the agent. So you can basically, and we'll talk about this a little bit further down, but you can request an accounting, and then the agent has 30 days to provide that accounting. You have a right to monitor your financials. So you have a right to ask for bank statements, credit card statements, credit reports at any time to monitor what the agent's doing. You can demand, as I just said, a regular accounting of of your financials. The standard is not to have it built into the power of attorney. I should say the state form doesn't have it built in, but you can if you want. You can require that the agent either provides, a monthly or a quarterly or every 6 months or annual, whatever, that they have to provide an accounting to you, and just put that in the original document so that they have to do it. The principal also then reserves the right to have the authority to give gifts. So they get to decide what, if any, gifting the agent may do, and have the right to put that in the power of attorney when created. This is actually one of my number one pieces of advice I tell clients if they want to do a power of attorney, is explicitly put in there that the agent cannot self-gift. So they can't take the person's money and just gift it to themselves. That is already in the statutes, but I think it's a lot more powerful to have it in the document. It really makes sure that the agent is put on notice. I will say another thing I tell clients to put in powers of attorney is what if any compensation the agent will get while they're acting as power of attorney. I don't have the statute in front of me, but I think the statute says they are entitled to reasonable compensation, which can vary. It could be 20 bucks an hour. If you have an attorney do it, it could be $300 an hour. So if there's already kind of an unspoken understanding between the principal and the agent, just put it in the document. And then, as we have kind of discussed already, they have the right to revoke the power of attorney at any time. You can even revoke it verbally. You can just tell them, hey, I don't want you to be in power of attorney anymore. Although, of course, we don't recommend that. You should always follow up in writing. All right, so let's talk about some red flags for financial exploitation. So, one red flag is isolating the elder, so not letting them talk to their other friends and family, not letting them go to church, kind of cutting them off from the support systems that they have. Another one is misleading or deceiving others about the elder's health. One we specifically see a lot is deceiving others about their mental health. So saying, oh, this person's crazy or they're senile, they don't really actually know what's going on. They can also exaggerate the elder's dependence on them. Oh, I do everything for them. Another one is threatening the elder. So threatening can come in many different forms. So it can say, "Hey, if I'm going to put you in an institution, if you don't go along with this, or I'm going to leave. I'm not going to help you anymore." Or of course, there's physical threats, threatening that they'll harm the person if they don't go along with the abuse. Or, and this is something we see pretty commonly, withholding grandchildren or affection from elders. That can be really difficult and can be a big barrier to elders reporting the abuses. They're worried that they're not going to see their grandkids again if they stand up to their kids. So another one is refusing to share elders' financial records or information. This is something we see a lot when we send a 30-day demand to provide an accounting. We either hear crickets or, they just refuse to share anything. Huge red flag that they're not managing correctly. This isn't always necessarily the case, but a lot of the times a red flag can be if the person has a criminal record, or they have spotty job history, and if it's hard for them to find a job, it's hard for them to hold down a job, and they are sitting on all this money for the agents, and one way or another, they oftentimes end up getting their hands on it. And another one can be really expensive habits or addictions, so alcohol or other drug abuse, gambling. If they previously, especially if they previously didn't have expensive habits, and all of a sudden they're making large purchases after they get control of their parents' money, that's a big red flag. All right, so this is my last slide before we again just go on to my final slide with my information. So this is talking about essentially what I do. So these are some of the civil legal remedies that are available for victims of financial exploitation. So there's one that we kind of talked about a little bit, but I want to go a little bit more in depth. So that's what we call the individual at risk injunction. And again, injunction is just a fancy word for a restraining order. So the benefit of this one, so it's a different restraining order from other restraining orders. So it's specifically for elderly people or disabled people that are the victim of abuse. And a lot of the times that's easier to prove, right? Like so for a harassment restraining order, you have to prove the statutory version of harassment, which is again, I don't have it in front of me, but it's like a course of conduct. So more times than, one or two, that has no purpose other than to harass. And that can be kind of a pain in the ass to show, pardon my French, but kind of a pain in the butt to prove in court. And then with the domestic abuse, again, there's a very specific statutory definition of domestic abuse that you have to meet to get a domestic abuse restraining order. So that's why I like this type of restraining order. So all you have to do is be 60 or older, or otherwise a vulnerable adult, and be facing or be threatened to face some sort of abuse. Much simpler, the elements that you have to prove. As with other restraining orders, there's criminal penalties if the person violates the restraining order. Another benefit is that there's no filing fee for this type of restraining order. Um, it it can also be filed by the individual. So that's typically what I do if I'm representing someone with capacity in restraining order action is I'll have their name as the petitioner, and then I'm just the attorney representing them. But you can also, or a concerned party can also file it. So a county could file it on behalf of the individual. A concerned neighbor could file it on behalf of the individual. One thing I will note, if it's filed by a concerned party, the court is required to appoint a guardian ad litem. So that's an attorney that gets involved, that kind of figures out what's going on, and then makes recommendations to the court as to what they believe is in the best interest of the petitioner, which might not necessarily be what the petitioner wants. And then it's pretty unlikely, but if a GAL is appointed, either the victim potentially, or maybe more likely the petitioner, could be ordered to pay those GAL fees. I've had it where the court will appoint a GAL on their own, and then will argue, hey, look, court, you didn't have to do this, you did this. I mean, it's fine that you did, but our client shouldn't have to pay the fees. And usually that works. Um, yeah, and then as I talked about the grounds for the what you have to prove to what the court has to see to order the restraining order is that the petitioner must have reasonable grounds to believe that the respondent or defendant has engaged in or threatened to engage in a number of abuses. And importantly, specifically listed is financial exploitation. So you can get this type of restraining order if the only abuse that exists is financial exploitation. Although I will say, if there's financial exploitation, there's almost always some other sort of abuse. All right, so another civil legal remedy is you can demand an accounting from the power of attorney. We've talked about this a little bit, but Wisconsin statutes specifically regulate transparency by fiscal agents. So agents have a duty to keep records. They have to keep receipts, records of all the money that came in or went out that they controlled on the principal's behalf. They have a duty to account to the principal, and they have a 30-day deadline to respond to requests by the principal. And then, as you know, we had kind of talked about this already, but also the agent has the right to, or other people, I believe, although again, I don't have the statute in front of me, they have the right to petition the court for review of the agent's conduct and then ask for appropriate relief if that conduct, violated any of their duties. And then another important thing is that based on Wisconsin law, it's not as crystal clear as I would like in that it's not like in the statute necessarily. It's through what we call common law or case law, so decisions decided by courts. But a failure by a fiduciary or by a power of attorney to account for the funds when demanded makes them liable for conversion. So anything that they can't account for, they're responsible for that amount of money. So as we had kind of talked about, conversion is basically just a fancy name for stealing, essentially. Conversion is usually used to mean personal property, and civil theft is usually what's used for money. But it's taking or conversion is taking or controlling another person's property without consent. So, for example, selling a vehicle that's titled to somebody else. So civil theft is a specific cause of action, so a reason for suing someone, and you can actually get up to 3 times the damages and costs for the victim of certain crimes. So identity theft, theft by fraud, those are known as punitive damages. So it's above and beyond the money that was actually lost. Punitive damages, it's meant to punish the person. I will note that even though the statute doesn't say this, there is if you look at the jury instructions, so these are instructions that are given to a jury when they decide a case, the jury instructions for civil theft make it clear that there is actually a higher burden of proof for civil theft. So that burden of proof is reasonable certainty by the greater weight of the credible evidence. So that's a little bit higher than the standard burden of proof for civil cases, which is preponderance of the evidence. So basically, slightly more likely than not, 51% likely. But this higher burden of proof is less than the criminal burden of proof, which is beyond a reasonable doubt. And then important to note for civil theft, you must prove intent. So you have to show that the person knew that they were stealing it, but there doesn't have to actually have been a criminal conviction. And then otherwise, other than the punitive stuff, the remedy is actual damages. So like replacement cost, not necessarily fair market value. So let's say they stole some property. It's more like, how much would this get at, or how much could you get it for at a rummage sale or Goodwill instead of, going and buying a brand new one. So another civil legal remedy, and again, this is a cause of action, is a breach of fiduciary duty. And then there's potential for punitive damages here as well. So it's when a fiscal agent, power of attorney, representative payee, etc., fails to act solely to the elder's benefit. So essentially, they use their money for themselves. They breach their fiduciary duty. This can include self-gifting, which, as we discussed, is not permissible unless it's specifically defined and allowed in the power of attorney document. And even then, it's only according to the elder's previously established patterns. So if the agent is self-gifting, they have to show, oh, this elder is always self-gifted to me. They'd give me $2,000 every Christmas. That's why I continued doing it. All right, another one is constructive trust. So this is not a cause of action. It's what we call a type of equitable relief. So essentially, constructive trust is a little bit confusing, but it's used to try to prevent unjust enrichment. And unjust enrichment is an equitable principle that nobody should be allowed to profit at another person's expense without making restitution for the reasonable value of that property, services, or other benefit that they unfairly received and retained that benefit, and it would be unjust for them to hold on to that. So constructive trust is used when someone holds legal title to property, but in fairness, like equity and good conscience is the legal term for it, the person shouldn't keep that property. So the court can then kind of treat the person that has that property as a constructive trustee. So essentially saying, yes, they have the property, but they're a trustee of that property, and then order them to transfer the property back to the rightful owner. So this is often used to enforce agreements between family members regarding property. Give me just a quick sec. All right, so another remedy is you can claim incapacity. You can basically say that the person did not have capacity to sign that document, make that transfer when it happened. So capacity is the sufficient mental ability to know what the person was doing when they did it and the nature or consequences of that transaction. So though I will note the law presumes capacity just of all adults unless proven otherwise. So if you're trying to invalidate or void a transaction and claiming that the person lacked capacity, the burden is on you to prove that the person lacked capacity. And you have to prove that at the time of the transaction. So just because someone, developed Alzheimer's later, you can't say, oh, 4 years ago they had the Alzheimer's, just they don't have capacity now, so we should reverse that. No, you have to go back and show that they didn't have capacity at the time. And then lastly, again, oh, no, I guess we didn't really talk about it. So lastly, you can claim that the abuser used undue influence. So this is essentially when someone imposes their own influence on somebody else and essentially overrides their free will. So the resulting action was the result of the will of the influencer, not of the person making the decision. And then you kind of get into like susceptibility to undue influence. So you can say due to a person's age or like a really suggestible personality or issues with their physical or mental health or kind of just a general inability to handle business affairs. So they're unsophisticated is what we call. Those can all lend to showing that someone was a victim of undue influence. And that's it. So again, on the right is my contact information. So that's my direct line. I can also text on that line, and then there's my email. And then on the left is our elder abuse email. So you can send documents or direct referrals there. And then our general intake line. So like I said, I'm open to warm referrals. You can feel free to call me, reach out to me. I can also actually, I don't think I had previously done that, but I can send Mike our copy of our referral form. I don't know if you have the ability to send that out to people. So yeah, again, you can either send it to me, send it to that elder abuse email, or if especially if it's not really an elder abusey issue that a client is having and you're just unsure, you can feel free to just send them to our intake line, and then they can determine whether or not they're eligible for our services.
Sure, Andrew, I can send anything you have out to the group here if you like. I see Maureen has her hand up. Maureen, feel free to unmute yourself and join us.
Hi, I had a question about from the very beginning when you were talking about legal action in general before you
Mhm.
talked about your own program.
Yeah, for sure.
You mentioned working with people on their criminal records and kind of scrubbing those for employment purposes. I'm wondering, do you do that for housing purposes?
So I don't personally, but yeah, sometimes we do. I think typically, and so again, you're gonna have to kind of bear with me here, take this with a little bit of grain of salt, because as I said, I don't personally do this, but I do know a lot of the times we do that, we do it for former clients. So, if we're already helping someone with an eviction, we can try to help seal or redact is what it's called in the eviction context. But I also know that we sometimes do clinics, and I will have
Yeah.
to double check. I think we either just did a clinic or we have a clinic coming up pretty soon here. Honestly, a lot of that is really funding specific. So like we'll hold clinics down in like Beloit specifically, like we have funding there. But I know that the clinic that either I think just happened, but either just happened or is going to happen soon is only for Dane County residents. Um, and it has to be a Dane County eviction. And I know that because I tried to get a client who's currently living in Dane County, but had an eviction down in Rat County, and unfortunately he didn't qualify for that. But so the
Well,
short answer is sometimes yes, but I'm not sure necessarily if like if someone calls in with that issue, I don't know whether they'll I kind of don't think they'll get through like to an advocate.
okay.
But intake unit might be able to like kind of provide some resources. Otherwise, if it is Dane County, I know sometimes we recommend they go to what's called SCAP, which is, I believe it's run by the Dane County Bar Association, and it's the Small Claims Assistance Program. I think it's at the courthouse, and so the person can go in there and get some free help, like filling out forms and stuff like that.
Okay. Yeah, I was thinking more in terms of people who are applying for housing. Not so much
I see what you're saying.
evictions, but people denied housing because of their background. And I have referred people often to the legal clinic that's held at the neighborhood house in Madison. Um, but I didn't know about the, what'd you say, SCAP?
Yep, SCAP, the Small Claims Assistance Program, and again, so that would be more specifically for trying to like expunged or like seal or redact previously existing evictions. And in my opinion,
Oh,
that's the
okay.
biggest reason that people tend to get rejected in
Yeah,
housing.
sure.
Other than, maybe they don't make enough, that you need to make like for most private landlords, they want to see at least a third of your not more than a third of your income is going to rent. But yeah, so I will say we don't typically help people like if they were denied just generally, with the possible exception of if someone's denied for or to subsidized housing, not just like put on a wait list or whatever, but they're either denied an application to subsidized housing or they're on subsidized housing and that gets revoked. That I believe is something that we do assist with.
Okay, thank you.
Absolutely.
Anybody else? Please feel free to chime in. And we got a few more minutes with Andrew. One thing I'm wondering, Andrew, is how do you decide actually of all of the cases that are out there, and I imagine there are a lot more than you can handle, how does the firm decide that this case merits our attention and this one should go to a for pay attorney, right? I mean, you guys offer an extremely valuable service. How do you decide to help somebody?
Yeah, absolutely. And I will say it's tough now compared to where we used to be when we had 7 or 8 full-time attorneys doing this work. So we back when I started this, we actually did all of our own intakes, and we actually had a separate phone line for anyone that was over 60. Would just go to that specific line, and we would do our own intakes. But now we have an intake unit, and so we kind of give them guidelines of the cases that we're open to accepting new clients on. And then they essentially filter out people if it's just something we don't help with. And that's why I said, I think fairly recently we made the change where scam victims just generally aren't getting through just because we really just don't have the bandwidth to assist. And most of their issues are not necessarily legal in terms of like being able to recoup money or that kind of thing. So yeah, so then if a person gets through that intake, then they get sent to us, and then within, I know it's kind of a long turnaround, but within 7 to 10 business days, we tell people we will get back to them. And I will say, essentially, everyone that gets to that point should at least should at least be provided advice. So it might not be something that we're going to jump in and file a lawsuit for them. But we can at least kind of provide them advice on what their options are and potentially also like brief service. So if they just need some forms drafted and sent somewhere, that kind of thing, or like a demand from the power of attorney to get their accounting, like that kind of stuff, we hopefully should be able to help with. But yeah, other than that, during the intake process, we collect all of their financial information. And so then if they have the resources to be able to hire an attorney, I can, again, at least provide them advice, maybe do some of the basic brief service work for them. But if they're going to need to hire an attorney to file a lawsuit, we can we usually refer people to the State Bar of Wisconsin has something called the lawyer referral service, where any attorney that engages with that service, they're private attorneys, so they're gonna, you're gonna have to pay private attorney rates, but they agree that for the first half-hour consultation, they won't charge more than $20. And again, we're usually providing that brief advice, but at least hopefully with a half-hour consultation, that attorney can then tell the person whether or not they'll be able to assist them or not.
Thanks. Anyone else? Please join us here if your questions, comments. Got a little bit more time. Anyone? Andrew, just one little bit here. There are a lot of state agencies working on these problems. To what degree are you proactively working with agencies, or do you wait for a case to come in and take it from there?
Yeah, I mean, it kind of depends. It's very fact specific. I think a lot of agencies, including like Adult Protective Services, and Aging and Disability Resource Centers, they will just send cases over to us, and then we'll see what we can do. But yeah, I mean, honestly, a lot of the people that we sort of oftentimes what we end up assisting with in terms of government employees is like either reporting to law enforcement, or working with law enforcement or the district attorney's office, to essentially exercise their rights as a crime victim. And then, I think throughout the firm as well, we have contacts with, the Department of Financial Institutions, with DATCAP, the Department of Agriculture, Trade, and Consumer Protection, so that we kind of can maybe help get over some of those hurdles in towards getting more information.
Great. That's what I was looking for. That's good. Okay. Anyone else? We're at 11, but seeing none, I guess. And Andrew, we're going to let you get back to work. Okay.
That sounds like a plan. Yeah, like I said, I'll send you over our referral form, and then yeah, if you could send that out to the people that joined, I would appreciate it.
I'll do that. And thank you again. Wonderful information. It's just, it's so complicated, for the average person. I'm glad we have you out there working for us.
Yep, absolutely. I'm glad I was able to take time to present to everybody today.
Perfect. Thank you very much.
Thanks, everybody.